All right. Well, this week's chapter is going to be Chapter 8 in the book, Pretrial Procedures in a Criminal Trial. If you get into the uniform side of law enforcement, you'll find that you'll spend a lot of time in the courtroom and testifying at trials, whether it be motions or criminal trials or civil trials. You'll spend a lot of time testifying. Objective number 1 for this module, this chapter, is to identify the steps in the pretrial process. That's before the trial starts. Basically what happens is when you're arrested in California, within 48 hours of the arrest, we need to bring you to court, tell you what the charges are, tell you what your constitutional rights. They give you a date of preliminary hearing and the amount of the bail. Now in California, before that, you have to have what's called a probable cause hearing, and that is even before your initial court appearance. And what that probable cause hearing is, the police officer has to inform the judge of the reasons for the arrest and the probable cause that led to the arrest, and the judge makes a determination of whether or not that probable cause is valid, and that's done by declaration. The officer fills out a PCD, probable cause declaration, faxes it or emails it over to the judge. The judge reviews it within that first 48 hours and faxes back and says, yeah, you have probable cause for arrest, go ahead and hold the guy in jail, or no, this arrest lacks probable cause, let him go, or I need more information before I can decide whether or not I'm going to keep the person. So after that probable cause declaration, you have the initial court appearance, which is called the arraignment. And that's when they're told of the charges. Now, pursuant to the Constitution, you have to be told what your charges are. They also afford you your constitutional rights, that you have the right to cross-examine witnesses, you have the right to remain silent, you can't be compelled to testify against yourself, you have the right to have an attorney, all those different rights. And if you read the chapter in the book, they talk a little more in depth about these rights. You're also given a date for a preliminary hearing. Now, in California, if it's a misdemeanor arrest, you don't have a preliminary hearing, you go straight to the court trial. But in a felony arrest, we discussed that in earlier chapters, ones where you're going to go to state prison, a felony, you're given what's called a preliminary hearing, a preliminary examination. At that time, you're told if you're allowed to have bail, and you do have the right to have bail, except for in certain cases, and that's a capital case. What a capital case is where there's a death penalty involved. So if it's a capital case, you do not, the judge can reject bail. There's some other circumstances too that can reject bail, but most of the time you're going to be able to post bail. Basically, the Eighth Amendment says that they can't impose excessive bail. So say you get arrested for drunk driving, they're not going to impose $1 million bail for drunk driving. You can have a hearing with the judge and say, hey, you know what, I think the bail you've assigned me is unreasonable. A good recent case, or a recent case that a lot of you may have heard about, was the George Zimmerman case. He was accused of murdering Trayvon Martin in Florida. It was the Stand Your Ground case. He felt his bail was excessive. The judge did not. They went back and forth, and they came up with a bail they thought was fair. And if you don't post bail, what happens is you sit in jail. Jails are overcrowded. They want to get rid of you as fast as they can. Sometimes if they can, they'll OR you, which means own recognizance. We'll talk about that in a future chapter. But most of the time you're going to have to post bail. Probable cause, 2 ways to do it. The first one is a preliminary hearing, and that's an open court hearing where you appear before the judge, and the judge hears the probable cause that the officer lays out and the prosecution lays out, and says this is the reason that we believe that this case should go to trial. It's like a pre-trial. It is a pre-trial where the judge figures out what's going on, and if there's enough evidence to send you over to trial. Now sometimes what will happen, that's for a felony, remember, a felony on a prelim. Sometimes what will happen, the judge say, hey, there's not enough here to charge a felony, but let's bump it down to a misdemeanor. Give me an example. If you're drunk driving and you cause injury, that normally is a felony case. But say the injury is really minor, like it's a bump or a bruise, nothing to require hospitalization, most likely they're not going to charge you with a felony. They're going to bump it down to a misdemeanor, and that might happen at the preliminary hearing. The other way they can do it is a grand jury hearing. The grand jury hearing is done before the grand jury. It's a private, the people don't know what's going on. It's a secret indictment. The nice thing about a grand jury is the prosecution can go in there and say you've got multiple defendants. Maybe you're working a drug case and you got multiple people you want to get put in jail, but you don't want everybody else to know that the other person's going to be going to jail. You go in for the grand jury, you provide all your evidence to the grand jury. The grand jury hears the case and will issue what's called an indictment. You may have heard of that. He was indicted by the grand jury. That's what that is, an indictment. And that's good to use when you've got multiple defendants, or maybe you've got a victim that you don't want to parade in front of the judge as little as possible, such as a case involving sexual misconduct, rape, sexual assault, something like that. Now, before a case even gets to trial, the prosecution has what's called case attrition. In other words, just because somebody gets arrested doesn't mean they're going to be going to jail. There's a whole, we're going to go over the next few slides here, a whole different, a whole way that the prosecution goes through the cases and decides, hey, which of these ones I'm going to try and which ones I'm not going to try in court. If every single defendant that got arrested ended up in court, the court system would be completely overwhelmed and would shut down within a couple of days. So we'll go over the triage system here and how they get that down. Basically, for every 100 people, like on the slide here, I'm almost reading from the slide, but for every 100 people arrested, 65 people get sent off, their adults get sent off to prosecution, or considered for prosecution. During that time, they're going to drop about 30 cases. And usually what happens is they'll decide, hey, you know, was this worth prosecuting? Are the witnesses good? You know, is it witnesses hesitant to testify? Maybe they are friends or relatives or something like that of the suspect and they're not willing to testify. Maybe even the victim's not willing to testify. Maybe the case just isn't that strong and so they'll dismiss the case. Or maybe it's in the interest of justice. You get arrested for being drunk in public. That's basically, well, they hold you in jail until you're sober. They don't usually prosecute those cases. It's a protective custody. They don't really care to take you to jail unless you get a whole bunch of cases like that. And on the other side, 35 of those 100 people are juveniles, and we'll talk about juvenile courts when we get over to the juvenile justice side, which I believe is chapter 10 or 11 in the book here. So of those 65 adults that are considered for prosecution, 35 cases get sent forward for prosecution. Of that, 30 cases will go to be set for trial. Doesn't mean they actually go to trial, it means they're set for trial. Of that, 3 people are acquitted. So of the 30 cases, you know, when they get sent forward to that prosecution, they're pretty solid cases at that point. That's why only 3 people are acquitted, which means they're let go, not guilty. Of the remaining 27, 4 actually go to trial and are found guilty. 23 just plead guilty. They say, hey, you know what, I'm going to take a lesser charge. I'm not going to waste my time. Some reason or another, they plead guilty. I used to make a lot of drunk driving arrests. Most drunk drivers, it's a pretty standard sentence. They don't bother to take you to court. They just go ahead and plead guilty to a case. Of those people, 27 are sentenced to some kind of a sentencing, and we'll talk about sentencing in a future chapter here. So 18 adults and 5 juveniles. Out of that original 100, only 18 adults or 5 juveniles actually end up in jail or prison. Another 9 are placed on probation. So that's what's called case attrition, the screening process, where 100 people get arrested and basically 18 adults end up in jail. Now we just explain how they screen the possible cases. Again, some of the screening factors they look at are, you know, was there enough evidence? And sometimes there isn't enough evidence. Maybe you get arrested for drugs, but it was not a usable amount. I've seen people get arrested for bindles of cocaine, but there was only powder, you know, minor powder in there, so there wasn't enough for conviction. The officer shouldn't even arrest them in the first place, but they did. Case priorities. You know, if I've got a murder case and a misdemeanor shoplifting, which case is going to go forward? You know, it's going to be the murder case. Again, uncooperative witnesses, talked about that. Defendants unwilling to testify against other offenders. That happens a lot, especially when you have a bunch of criminals doing crime against each other, which happens quite a lot. A couple of ways you can plead guilty. You can either plead, well, actually, when you show up at the arraignment, that's your first court appearance, you're required to enter a plea of either guilty, not guilty, or nolo contendere. Let me back up just a minute here. In the face-to-face class, a lot of times I'll show scenes from the movie My Cousin Vinny. If you've never seen that movie, it's a great movie in that it takes you through the criminal trial from the arrest, from the crime actually, all the way through the arrest, through all the different processes of trials. I think you can get it on Netflix if you want. Unfortunately, it's copyrighted, so I can't put any of it up on the internet here. But if you were in the face-to-face class, you'd see some scenes from that. So if you get a chance to rent it, it's a nice movie to watch. It's kind of a comedy. If you haven't seen it, Joe Pesci, Melissa Torme. One of the funny scenes in there is where Joe Pesci is the attorney, and Joe Pesci gets up before the judge, and the judge says, how do you plead? And he starts talking something about the case, and he says, I only want to hear guilty or not guilty, and it goes on, and Joe Pesci ends up finally getting put in contempt of court. But anyway, guilty means that you did it. You're willing to say before the judge, yeah, I did it. Not guilty means I don't think I did it, and I don't think you can prove it. Nolo contendere, which means no contest, is sometimes accepted by the court in lieu of a guilty plea. The main difference is, in a nolo contendere, you're not saying you did it, but what you're saying is you don't believe that you can put up a good enough defense and that you're probably going to get found guilty anyway. One of the main advantages of the nolo contendere is they can't use it in the civil trial later on. One of the cases I like to talk a lot about is the O.J. Simpson case. The O.J. Simpson case was a case where O.J. Simpson was a football player who was accused of murdering his wife. The criminal trial, very famous one, he was found not guilty in a criminal trial. However, he went to civil trial afterwards on a wrongful death, and we'll talk about the burden of proof here a little bit later on. But the burden of proof was a lot less in the civil trial. In the civil trial, they found, in fact, that he did murder these people, and so they found him guilty in that civil trial. But in a civil trial, you can't go to jail, so you can only get fined. They took away his Heisman Trophy and his property and stuff like that. But a nolo contendere plea they can't use against you later on in court in a civil trial. So if you go to a civil trial and say you're drunk driving, you run over somebody and you hurt them, kill them, and you get a wrongful death lawsuit against you by the family. If you get found guilty or plead guilty, you're automatically assumed to have done whatever it is you're accused of doing in the civil trial. So the nolo contendere plea can't be used against you in a civil trial. That's one of the main reasons a lot of people use it. Plea bargaining, they do that a lot. What plea bargaining is basically is they'll offer you a lesser charge, maybe a reduced fine, community service, something like that to keep you from going to trial. Again, if 100 people went to trial, 100% of the arrests went to trial, the criminal justice system would grind to a halt. So plea bargaining is one of the ways they reduce charges. Reduce the number of cases that go to trial. You get a quick conviction. Prosecutors get a quick conviction out of it. The defendants sometimes get a better break on it. And sometimes they can get a lighter sentence, or they just want to get it done with. Again, I go back to drunk driving, which I did a lot of arrests for drunk driving. The only thing they care about is just to get the thing out of the way, start doing their time and get it done. So, what are some of the protections you have as a criminal defendant? You think about it. You may have watched TV, Law and Order, any kind of cop show. You'll see that the criminal defendants have some rights. We talked a little bit about it back in the chapter we talked about the Constitution. We'll talk more about it now. Speedy trial. Basically, you have the right to have a speedy trial, and normally it's 45 to 60 days between the time of arrest and the time you get the trial. Now, does that always happen that way? Not at all. Most people want to delay the trial if they're guilty because they're hoping in one of several things, hoping they can find more evidence to help their defense out. Maybe they're trying to work a plea deal in the meantime. Maybe they're hoping the officer or the witnesses go away, move away, something like that. They're hoping for something to happen in their favor. And so cases very seldom go to trial quickly within the speedy trial. On the other hand, though, in the United States, if you get arrested on something, you're going to trial within a pretty quick time. And that doesn't happen the same way in other countries. You can go to Thailand, for instance. You get arrested in Thailand, they can keep you in jail for years without charging you. Now, one of the questions we used to talk about a lot are what happens with Guantanamo Bay. If you're familiar with Guantanamo Bay, it's where we send terrorists or suspected terrorists, and they get held there without a trial. Well, guess what? It's not the United States. They're not United States citizens. Constitution doesn't apply. That's been a big argument. You remember the president, when Obama was elected, he said, "I'm shutting down Gitmo." That was 6 years ago now, almost 7 years. He hasn't shut down Gitmo. He's got to know more than we do, I believe. That's why it's still open. Sixth Amendment also guarantees an impartial jury of your peers. Some states have fewer members, some states have 10, some have 6, but in California we have 12 members of a jury. And in order to convict you or acquit you, it has to be unanimous. All 12 have to say yes or have to say no. Maybe you've seen the old movie 12 Angry Men. It's an old movie from the 40s, Henry Fonda. It was an original 11-1 for conviction, and then they, I won't ruin the movie, but they talk it out and they change their verdict. But anyway, it has to be unanimous. So what happens if 11 people say guilty and one says not guilty? What happens? We'll talk about that in a minute, but that's a mistrial. Jury selection, what happens is they have a master list of people that they choose for jury. In California, most of the time they get it off of the voter rolls, property tax rolls, and DMV rolls. So if you got a driver's license, or you pay taxes, or you're registered to vote, that's where they find you from. You might get called to jury duty. When I was a police officer, you got an automatic exemption from jury duty that you didn't have to serve. But once you retire, you no longer have that exemption. The reason they have an exemption is because they want to make sure you're still out on the road, working the road, and doing what needs to get done out there. So anyway, I had to go to jury duty a couple of semesters ago. Went in there. It was a auto accident case. You know, I remember I was a traffic cop for years, and then there was also a medical thing involved too. It was a civil case. They ended up not selecting me. They ended up getting rid of me, and I'll talk about that when we get to that section of this lecture here. Before they choose you as a jury, they do what's called voir dire. And what voir dire means is to ask you certain questions to determine your suitability. Some of the questions they'll ask you, you know, what your religion are. You look on the clipboard here on the thing here. They talk you about different groups you belong to. What they're trying to see is if you have any kind of a bias. You know, if you're an NRA member, you know, pro-gun person, in this case involves a gun, that might bias your decision. You know, maybe if you've got some prejudicial biases, maybe you don't like certain races, maybe you don't like certain religions, something like that, that might bias you. So if they have some kind of a bias, they can do what's called a peremptory challenge, which means, hey, Your Honor, let me give you an example. I'm a police officer. If I were to testify in a case, the peremptory challenge might be, hey, this guy would more likely to believe his brother or sister police officer on the stand there. That's one of the things they'll ask you too. Any relatives in law enforcement? How do you feel about police officer's testimony? So they ask you all these questions. And now if they feel you're going to be a good jury, they can keep you on there, juror. But if not, and if they still can't get rid of you, they can do what's called a challenge for cause. Peremptory challenge. Challenge for cause is that basically says there's a justifiable reason. You know, one of those prejudices I talked about, one of those preconceived, you know, person wouldn't be here if they weren't guilty, you know, police don't ever make bad arrests, that type of thing. That's a challenge for cause. Peremptory challenge basically says, juror number 7, you're gone. They don't have to tell you why. They just didn't want you on the trial. That's what they had to use to get rid of me, the peremptory challenge. Because every time they asked me if I could make a fair decision, I said yes, I can make a fair decision. So they couldn't get rid of me on cause, but they could get rid of me on the peremptory challenge. So they did. Which is kind of disappointing because I wanted to see what it was like to be on the jury. I've only seen the testimony side from my testimony, their expert witness testimonies. I've never actually sat on a jury before. Maybe some of you have. Once you get to the trial, the way the trial sequence works is the prosecution goes first. The reason the prosecution goes first is they have the burden of proof. They give what's called their opening statement. They talk about what they believe evidence they have, which they give like a preview of the case basically. This is what's going to happen in this case. This is what I'm going to do. And then the defense comes back with their opening argument too. They try to do a roadmap of what's going to happen in the case. Next learning objective we're talking about is explain the difference between testimony and real evidence, and between lay witnesses and expert witnesses, and we'll talk about the different evidence you can see in court. Testimony are statements by competent witnesses who are under oath. What's a competent witness? Just about anybody. You can be a complete idiot, but you still could be a competent witness. An incompetent witness might be a young child. We're talking 2 and 3 years old. They might be considered an incompetent witness, or somebody with a mental disability which prevents them from knowing the difference between right and wrong. That could be an incompetent witness. Real evidence is the stuff you can touch, see, use your senses, touch, smell, see, and that's to show a point of the trial. We'll talk about that in a minute here. Lay witnesses. Lay witnesses are anybody that can come in and talk to the jury and describe whatever they saw. So say you're sitting out in front of your house and you see somebody climb into the neighbor's windows, your neighbor's window. So you call 911, say, yeah, a guy in a gray shirt and a blue cap just climbed into my neighbor's window. The police get there. He's climbing back out with a TV set under his arm, and they arrest him. You'd go in as a lay witness and testify, this is what I saw. An expert witness is somebody that can testify based on their professional training that whatever evidence is presented means something in the trial. So given that same set of circumstances, you see this guy climb through the window, the detectives will go in later on, the crime scene person will go in later on, they'll fingerprint the house and they'll show wherever this person was. And you'll have a fingerprints expert come in and say, yes, I'm an expert in fingerprints, and the fingerprints lifted from the house match this defendant here, and this is why, and they'll point out what the expertise they have. Direct evidence shows a direct fact in the case. Circumstantial it shows that it infers a fact. So direct evidence, you take a knife, you stab somebody, and you leave it in the crook. And that's a direct evidence that knife there still left at the scene. Sorry, not the crook. The victim has a knife in him still. But anyway, that knife still at the scene. That's direct evidence. That shows that this was a murder weapon. That's evidence can be used. Circumstantial evidence might be. I got a good case I had a case where we had a footprint in the mud of a boot, and the boot was pretty distinct because it had a marking on the sole. We later found out it was caused because he'd stepped on a tailpipe that had burned that mark in the sole of the foot. So when we were doing the investigation at the house, we saw the footprints. We took plaster castings to the footprints. We later on went to another suspect's house, found those same boots. During the questioning, it's kind of an interesting line of questioning. I kept asking him about wearing his roommate's clothes, and do guys do that? I know girls do that. Do guys do that? And he kept, what are you talking about? What do you think, I'm some kind of idiot? And I got him to say no, that nobody else wears his clothes besides him. Then I bring out the boot and I bring out the footprint, and I say, you know what? Here's your footprint. It was at the scene of this crime here. Tell me about it. That was circumstantial evidence. Prosecution helps determine the corpus delicti. We talked about that in a previous chapter. That's the body of the crime, the elements needed. They call the witnesses for direct examination. That's to tell about what the crime was about. You can't ask leading questions. You can't ask, what was it like to watch the defendant shoot the suspect? You can ask, what did you see? I saw the suspect shoot the defendant. I saw that gentleman sitting in the chair over there shoot my neighbor Jim, who ended up dying. So that would be a question they'd ask. Now, the Constitution allows the person who's in charge of a crime to confront the witness. In other words, they can cross-examine the witness. So they can go in and ask questions about the witness. Now, if you get a chance to see that movie, My Cousin Vinny, the cross-examination scenes are the best. Joe Pesci cross-examining. It's great cross-examination scenes. Defense strategy. Now remember, the prosecution has the burden of proof in this case here, so the defense can do several things. One of the things they can say is ask for summary judgment. In other words, at the end of the testimony of the prosecution, they can go to the judge and say, you know what, I'd like to have this whole thing dismissed because the prosecution hasn't proved anything. And every once in a while, the judge says, oh yeah, you're right, they haven't proven anything at all, nothing. So they can simply rest the case, or they can try to show some reasonable doubt. We'll talk about the burden of proof here in a few minutes. They might present a defense, an affirmative defense. We've talked about defenses in the past, some of the affirmative defenses you can put forward. Self-defense, insanity, entrapment. We talked about those in a prior chapter. During rebuttal, the prosecution can bring in evidence to rebut whatever the defense brings forward. You see this a lot in expert testimony. Maybe it's a case where they're trying to show that the defendant was not psychologically sound. It's an insanity case. The defense will bring in somebody who says, oh yeah, my guy's a nutcase, he doesn't know right from wrong. The prosecution will bring in their witness that says, no, I think the defense witness is wrong. This guy knows right from wrong. He should be tried for this case. It goes back and forth until they finally get to the closing arguments. Remember, the prosecution has the burden of proof. So at the end of the trial, the defense attorney goes first, and then the prosecution has the last word. So the prosecution goes first in the trial, and the prosecution goes very last in the trial. You might see that as a test question later on. Once the trial's over with, the case is given to the jury. The jury looks at it, and they come up with a decision. Remember, I said earlier, it has to be a unanimous decision. So if I've got 6 people that want to find him guilty and 6 people that don't want to find him not guilty, that's a hung jury. They're given several chances to try to make a decision, and then it has to be unanimous either way. Now what happens is, if it's a hung jury, the prosecution can decide, yeah, there's enough evidence to keep going forward and try it again, or the judge can dismiss the case with prejudice. What that means is he dismisses the case, he or she dismisses the case and says, there's nothing to this case, we don't want you bringing it back again. I've seen it where they've gone 2 or 3 times trying to get a conviction, and finally they gave up, or the judge dismissed it with prejudice so they couldn't come back again. Now once they're convicted of a crime, they can appeal the crime. Appeal is done, we talked about this in the last chapter, their appeals are done on judicial error, such as there was some evidence that was let in, or there was misconduct. Either the defense attorney was not correct, or they find out that somebody was lying in the trial. Just because you don't like a verdict doesn't mean that you can take it to appeals. And we talked about appeals in the earlier chapter. Double jeopardy. I love the show Jeopardy, if you guys ever watch it. But anyway, double jeopardy says that you can't be tried for the same case twice. In other words, you get found not guilty of murder, we can't take you back and say, well, let's try it again. Let's try it again. Let's try it again. It's not that same thing in other countries. In other countries, they get multiple attempts at it, but in the United States, we don't. You get one shot at it to find them guilty or not, and if you don't, you're done. So that's what happened in the Trayvon Martin and George Zimmerman case. The jury wasn't given the option of choosing a lesser charge, and they found him not guilty, and so they couldn't go back and try him on the same charges again. Now, you may know about the Rodney King incident, where the LA police officers beat Rodney King, and they were found not guilty in the state court, and they were found guilty in the federal charges. Well, the difference was the federal charges were civil rights charges. It was a different crime. The state charges, whether they were charged the officers with assault under color of authority. The federal charges said they violated Rodney King's civil rights, and they were found to have violated civil rights. Not many of you probably were around when Rodney King was, maybe you were first born. It was 1991, so a lot of you were first born when Rodney King case went down. Alright, so that's the end of chapter 8. Hopefully you learned something in this chapter. There's some other assignments to do. Make sure you check the chapter list. Thanks a lot.